appeal to the appellant in this matter.
What is this office objection at
So there is
11?
the office objection is there are 4 documents they say is unclear in the respondent's documents. I'm not going to rely on them for now. But I've provided translations of those documents already.
You have provided translations, so legible copies are not required.
Those legible copies may not be required for now, my lord. If required, I'll submit it later.
Then Chinnappan and senior counsel, he has provided translated copies of annexures 3, 10, 11, 1 capital A and R14. The production of the legible copies thereof may be dispensed with for now.
Yes.
The translated copies are put on record. 4 weeks' time is granted to place on record the legible copies.
I'm there.
Pictures.
Now, my lord,
You are appearing. Just one moment.
I undertake to appear for respond number 5, Mantralaya Matter.
That the AGA accepts notice for respond number 1 to 4. Sri Augustine accepts notice for respond number 5. Yes. Yes, Mr.
my lord, this pertains to a particular area called Sri Kshetra Bichali, which, my lord, has been in the custody of our clients from 1950s. It's of course for generations, but from 1950s, the records show that we've established this entire area. And I must point out, my lord, we're all in unauthorized occupation of this property. And we also made an application for grant of these lands under the land grant rules. Then, my lord, the Raghavendra Swami Matha also makes an application in 2020 saying, grant this land in our favor. At that point in time, my lord, both applications are pending. There are also certain trusts, my lord, which we have created. There were some disputes between us. That disputes were in a civil court. All of that was going on. Now, the grant that has been made is under Rule 108 of the Karnataka Land Revenue Rules, which is, my lord, with respect to unauthorized occupants. I am the only unauthorized occupant here. They don't claim as unauthorized occupants. The government grants land on the basis of Rule 108 and, my lord, exercises power under Rule 108N to try to, my lord, relax certain conditions with respect to the land. But the entire chapter does not apply to them because they are not an unauthorized occupation. And the order is passed, not saying I have no locus standi to challenge it. When admittedly I am in possession and there's no dispute of the fact that I've been in possession of this property.
108.
108. Lordship, can you see Rule 108? It comes under, my lord, Chapter 13A.
Just one moment.
Sorry.
This is the Brindavana of Sri Raghavendra Swami.
Yes, my lord. There's a, no, not of Raghavendra
And
Swami.
you say Raghavendra Swami Mutt doesn't have a claim over Raghavendra Swami's Brindavana.
No, not that way. The Brindavana, my lord, is on the banks of the river Tungabhadra. Survey number 35 and survey number 37.
Brindavana, from what we have seen, Brindavana is of Sri Raghavendra Swami.
Built by Appannacharya, my lord. It's
Not
a
of any other.
Brindavana. It's a Brindavana built by one Appannacharya of Raghavendra Swami. But this entire area, my lord, was never touched by Raghavendra Swami Matha till today. This entire thing was always the puja and all of that.
No, Raghavendra, you can make your wish to
Go on,
answer
go
the
ahead.
question.
Yes,
Is the Brindavana is of that of Sri Raghavendra Swami?
yes. Yes, my lord.
108C.
Lord, 108, Lord, kindly see, comes under chapter 13. Chapter 13b, my lord. Sorry. Chapter 13c, 108. I'm so sorry. 13a, my lord. Chapter 13a, 108b, it starts with regularization of unauthorized occupation of land.
Yes.
Please see 108C, my lord. Any person who is an unauthorized occupation of any land may make an application in writing to Tahsildar along with a fee of ₹2 payable by affixing a court fee stamp. Then there's a procedure under 108CC and then 108CCC. Then there's a committee which has to examine it. And then, my lord, you'll also kindly see 108I, certain lands not to be granted. This has been relaxed in their favor, but the grant has been made under 108, my lord, of
Grant is made under
108J. Conditions under 108.
conditions under which are you reading?
108N is the power of the state government to relax certain conditions. And the conditions which are relaxed, 108I, 108N. And the conditions which are relaxed are at 108I. Which, my lord, are, if I may read that, notwithstanding anything contained in this chapter, lands assigned for special purpose under section 71, lands described in revenue records as Devara Kadu, Urduve, Gundutop tank bed, this is the tank bed, Food Kara Halla, burial grounds, and such lands in the opinion of the state government is required for public purpose shall not be granted. This condition has been relaxed and the land has been granted. But the grant of the land is as if they are unauthorized occupants, and that is not their case. They also admit that we are the ones who have been maintaining, managing, and taking care of this Vrindavana for decades. From the 1950s, my lord, our entire establishment is here.
What establishment is there?
Lord, we have set up, my lord, Aduge Shale, Kutira. There is a space for tourists to come and rest. There's a Goshala. And all of this, my lord, has been in existence for decades. As a matter of fact, that is admitted by the state government because they produce all the reports, where each report shows the existence of these structures. And, my lord, this entire Vrindavana and the puja has been conducted by us. I made a mistake, my lord. When we said Vrindavana of Sri Raghavendra Swami, Lord, the real Vrindavana is in Mantralaya, of course. This is, my lord, a Jyoti Swarupa here. Because he had come there and, my lord, an idol was kept there on the banks of the river Tungabhadra. So these are the areas, my lord, around the bank of river Tungabhadra which have been developed by us in the 1950s. And after everything has been developed now, Raghavendra Swami Matta for the first time, my lord, comes in 2020 and makes an application saying, please grant the lands in my favor. Exercising powers under 108N, grant is made to the government, which in my humble submission could never have been done in favor of the Matha. Now, my lord, the learned single judge says that though
where is your application? application for grant?
My,
Where
my,
is your
application,
application for grant?
my application for grant note is at page 136. 13. That is a translated copy.
Next year, D of the writ petition.
Yes, yes. 136. In Kannada, my lord, it starts at page 134. The translation is at 136.
Where is the application of respond number 5?
Respond number 5's application, lord, is in volume number 3, page number 502, Annexure R7.
That's records is to be called for writ petition. Records of the writ petition are to be called for. They are not filed. I have filed all those volumes.
They
No, it's-
produced 502 R7.
It's not given to me.
Volume 3.
Volume 3.
Volume 3 volumes have.
So sorry, my lord. Lordship, can you
You
take
filed
any?
a
R5.
suit in OS 113.
That was a suit, not
What is
between.
OS 1?
I'll tell you what. We had filed a suit between the two. There was a two rival files for puja rights. Therefore, there was suit, not which were pending that ultimately ended in a settlement. And then came together, and now, my lord, that dispute has come to an end because at that point in time there was a dispute on puja rights. As my lord is common the case of all these matas, it's not like Raghavendra Swami Mata has not been fighting litigation against various parties. At least we know of at least a half a dozen litigations which are pending with respect to the Mata. So that has made a big issue saying, oh, they are fighting amongst themselves, therefore they are not entitled to grant. In my humble submission, that can't be the reason.
What is OS 59?
Suit for those possession.
But there they had filed a suit claiming adverse possession of these
Which has
lands.
been
Have
withdrawn.
you produced the plaint?
That suit has been withdrawn. my lord. That suit has been withdrawn.
Withdrawn that.
Have you produced the plaint?
Plaint has been produced. my lord. As a matter of fact,
Yes, it's produced.
Page
Produced.
State for adverse position, my lord.
It's produced.
against whom?
It's
Against the
Against the
government.
government.
236, your lordships.
Annexure
Plaint is
D,
at
my lord.
236.
Lord, Annexure D is their application.
236, OS number 59 or 22.
They have filed that application in the process.
Where the plaintiff in that suit?
236, volume 1.
286.
36, no, 236.
236. So there was no trust in existence.
No, but the claim was made by the individuals only. There are two trusts also, my lord, which are formed by us. There are two trusts. I'm not disputing the fact that there are two trusts also formed by us for the maintenance and management of the temples.
Writ petitioner number 1 and 3 constituted one trust, 3 and 4 constituted another rival trust. Both of them, they filed in 113, OS 113, Bitterly Melbourne.
This was a suit you filed in 2022.
Yes, my lord.
Now you want to invoke 108A, 108B of chapter 13.
Yes, my lord. My lord, there are two parts, my lord. One is the
And
grant of land.
You are asking for regularization,
Yes,
not for grant. Once
You know,
come under chapter 13A,
chapter 13 will be
you are
regularization.
asking for regularization of unauthorized occupation.
Yes.
Now, the committee which is in the clause AA
My
of
lord.
108B
Yes.
refers to 94A committee.
Yes, my lord.
Now, 94A committee so many provisos. Subsection 4. 1, 2, 3, 4, 5. The fifth proviso, last but one proviso
Of 3, my lord. Of 94A3.
of 94.
I'm sorry, I couldn't hear your lordship.
Last but one proviso before that explanation of subsection 4.
Of section 94, my lord.
94A.
Yes, my lord. Regularization of unauthorized occupation by constituting a committee. Yes.
You have to make that application within 3 months from the date of commencement for the committee to consider. You've made the application in 2006,
Yes,
and even after filing an application in 2006,
my
you
lord.
set up a claim of adverse possession in 2022.
Yes, my lord. Yes, my lord.
Advise your clients properly, Mr. Kinappa. What is this? Raghavan Swami, they want to
No,
take it away from the Raghavan Swami. What?
No, no, this, my lord, there are certain rights, my lord, which we also have as individuals who've been carrying out the puja of this entire area for decades, according to us, for generations. Because Raghavendra Swami is supposed to have come to this area and blessed this place, which is why, my lord, a certain area was identified. And it is not the case, my lord, that Raghavendra Swami was conducting any puja here. And if they were not conducting any puja here, now for the first time they make an application in the year 2021.
But you are not within the time frame of 3 months from the date of coming into force of the amendment.
Whether
You filed it in 2006. You filed a adverse possession suit against the government.
yes, my lord, if my possession is
You have
anyway
withdrawn.
adverse, unauthorized, my lord, may I just say this? Unauthorized occupation of land in any event, my lord, is going to be adverse to the interest of the government. And when I make a request, my lord, it is one is my request for grant of land in my favor. The other is a grant being sought by someone else, Raghavendra Swami Mata, who has filed an application against us and say that don't grant them land, grant us land. And thereafter, my lord, how do they get a grant on 108 on the same principle if it is unauthorized occupation? That grant cannot sustain. And being an occupant, Lord, I'm the only one who can challenge it.
Look at your prayers that you have sought for at page 250. Grant a decree of declaration declaring that the plaintiff have perfected the title for suit property by way of adverse possession.
Yes.
Prayer 2 is even a fantastic prayer. grant a decree declaring that if any land grant order is made in favor of any trust, association, organization, mutt, or any other legal entities during the pendency of this suit, it is to be declared as not binding upon the plaintiffs or their right of adverse possession.
Yes.
You yourself have recognized Mata there. Grant a
No.
decree of repossession in case the plaintiffs are evicted by defendants. Grant a decree of consequential injunction restraining defendants or anybody else stemming through or from interfering with the peaceful possession.
Yes. Yes. But
And then you have withdrawn.
is withdrawn, but that only takes away, my lord, at best my right to claim an adverse possession today. And someone else, with respect to, my lord, a property which is in my occupation, I'm entitled to say so. Because if that grant is illegal, contrary to law, my lord, I'm entitled to come before your lordships and say that the grant is illegal, could never have been done. Whether, my lord, whether land is granted to me or not, to grant land in favor of someone else, my lord, land grant rules. Grant of
What is
land,
the violation according to you?
my lord, they are not an unauthorized
What
occupation.
is the violation?
108, my lord, applies only in a case where a person is in unauthorized occupation of the land. It can't be applied to anyone else. Raghavendra Swami Matha is not in unauthorized occupation of the land. As a matter of fact, they're asking for grant for the first time. And the entire chapter 13, my lord, does not apply to a scenario of this kind. It applies only in a scenario where someone is in unauthorized. And my lord, please see their conduct. The order was passed. Within 10 days, my lord, entire posse of police officers have come and to try and take possession on 13. Yesterday night, my lord, they come and say we want to put up boards property, and they say, and even in the report, Mahazar, there is a report that entire area is constructed and we are occupying that entire area. And when all of that is there, today to, my lord, turn around and say that I'll grant the land in favor of someone else while ignoring my application. Government, my lord, can't have an approach, my lord, where they will ignore a person who's in occupation and grant land in favor of someone who's not in occupation, using the power to grant land of unauthorized occupants. And that is a provision at 108.
Let him complete it. Yes. So they were not in unauthorized occupation, they could not have applied for.
Lord, there is no dispute, and I'll show you, lordships, not all the reports from Annexure F onwards, where the officers of the government have issued reports very clearly saying that we are the ones who are in occupation of these properties. Annexure F to F9 contain all those reports. I can take your lordships, my lord, if your lordships would like to see them, where there is no dispute on the fact that we are the ones in unauthorized occupation of land. Now, having done that, please see the grant order at page 255.
255.
255 is in Kannada, 257 is in English.
Yes.
This is the grant order to the government on the basis of a DC proposal. May I just read it, Lord? 257.
Yes, please.
The Deputy Commissioner Right in his proposal dated 36/21 has already encroached upon 1 acre of 2 guntas in government Porumbok and 1 acre 31 Kharija Katta acres of land in survey number 35 of Bichalli village of Raichur Taluk. Members of Japada Katte Appanacharya Seva, that is the petitioners, are mostly from the same family, and there is a suit number 113 of 2016 pending between them in the Honorable First Edition Civil Court, Raichur. It was not pending, it's disposed of, it's settled. Said suit is related only to the worship of the temple, that is that temple. Government has submitted a 5-year audit report in relation to the Sri Mutt, that is Sri Mutt, not respond number 5, requesting the government to allocate the proposed land to Sri Raghavendra Mutt, Nanjangud, Mysore district, Mantrayala camp for the development of the historical site of Raghavendra Swami's religious and tourist places. Government, having thoroughly examined proposal of DC, has ordered as follows. In exercise of powers conferred by Rule 108N of the Karnataka Land Revenue Rules, in relaxation to Rule 108I, after depriving public right of 1 acre 2 guntas of government Porumbuk land in survey number 35 of Bichalli village under section 68 of the Karnataka Land Revenue Act, 1 acre 2 guntas in survey number 35, 1 acre 31 guntas in survey number 37 in Bichalli village in Raichur Taluk, a total of 2 acres 33 guntas of government land for the purpose of developing the historical place of Sri Raghavendra Swami as religious and tourist places by charging 50% of guideline value and other statutory charges as per Rule 22A14 of the Karnataka Land Grant. That is, of course, on fixing of the amount. Raghavendra Swami Matta has been ordered to be sanctioned to the Mantralaya Camp Matta. As a matter of fact, Lord, this is a religious matter. The requirement, even under land grant rules, is you can only grant to a religious and charitable institution, not just a religious institution. Therefore, there is no power exercised under the land grant rules to grant. Power exercised by the government is under 108. If Rule 108 is invoked, you must first satisfy the fundamental requirement that you are in unauthorized occupation of the land. If you don't satisfy that requirement, in my humble submission, the exercise of power is illegal. And therefore, the question of, I'm sorry, my lord was.
Yes, go ahead.
No, I thought your lordship wanted to ask me something. That's why I stopped now.
The screen is on the left-hand side, so it looks like we have turned to the left.
Yes, sir. Yes, I'm sorry. I'm mistaken.
We are looking at you.
Yes, sir. No, I thought you
In the
were. Yes. Sir. Now, my lord,
Yes.
given this scenario, there is no power exercised under land grant rules. Even under the land grant rules, if your lordship sees Rule 21, Rule 21 requires it to be both a religious and a charitable institution. It is only a religious institution. It is not classified as a charitable institution. Land grant
Rule 21.
Rule 21, as a matter of fact, not the earlier provision provided for grant of land to religious or charitable institutions. By the 2013 amendment, 18 amendment, that was modified to say religious and charitable institutions. So you must be both. Notwithstanding anything contained in these rules, the EC with the prior approval of government may grant lands to religious and charitable institutions subject to the following conditions, namely: 1. Extent of land to be granted should be assessed keeping in view of the purpose of grant, present financial condition and capability of the institution, taking into account the scarcity of availability of land. No land should be granted in excess of the immediate requirement of the institution concerned. While fixing the price of land to be granted for non-agricultural purposes, following conditions shall be allowed, namely: A. No concession in the price of land shall be given to the institution. Now, 50% is the guideline values what is given by them. Provided that the institution is run purely for religious and charitable purposes, such as temples, leprosy treatment center, old age homes, orphanages, and homes of physically and mentally challenged persons, without collecting any fee or service charge, may be granted under this proviso 50% of the market value or guidance value, whichever is higher, on application made by the institution concerned. Application for concession shall be accompanied with supporting documents for a period of 5 years prior to the date of application in proof of their statutory satisfactory function. And most importantly, my lord, is 21(1), where it says no land shall be granted in excess of the immediate requirement of the institution concerned. Therefore, each of these conditions have to be considered by the government, even if you are going to consider an application under Rule 21 of the land grant rules. But the grant is not made under that provision. Grant is made under 108, because if you lordship see, even under land grant rules, there is a provision to relax conditions. Under Rule 27, not exercised. The grant cannot be made under Rule 21, and therefore the grant is made under Rule 108, which in my respectful submission could never be.
Yes.
Now, my lord, throughout the process, I'll show you lordship the documents. You know it.
Yes.
Lordship will hear this matter.
First, you have to make out a ground for admission.
Yes.
So far, we don't feel anything. So if the admission is not made out, we will pass orders on the matter.
Of course, of course, of course. Now, my lord, my respectful submission is not Rule 108 could never have been invoked. If Rule 108 could not have been invoked, then in my respectful submission, the question of granting of this land to the MUT can't arise. Land grant rules have not been adopted at all. Now, their application, of course, my lord, was under the land grant rules. If your lordships take page 526, their application was under the land grant rules. But that was not the power exercised by the government.
26.
526 in volume number 3.
Yes. R10A.
R10A, my lord, if I may humbly request, my lord, to kindly see 1, 2, 3, 4. The fourth column.
69, Niyama 21.
21.
Yes.
Though this application is made under this provision, this is not the provision that is exercised by the government to grant land. Now, if you have not exercised the power to grant land under this provision, then Lord, there has to be some other provision under which is applicable to them. And that is certainly not 108.
When was this? This was made in 21.
21, Lord. This is 2021.
1421.
And then, of course, my lord, though
Yes.
my applications have been pending for years, they don't consider it. So far as this application is concerned, everyone jumps into great action, and within no time, action is taken. If your lordship sees this date, as to how quickly, my lord, action is taken so far as they are concerned, everything is done on the same day. If your lordship sees annexure F onward, at page number 100, page 147, my lord. First is the Panchanama. The Panchanama, my lord, is there, where your lordship will find there is a reference to the fact that if Special Assistant to Muttakan Mantral Nanjan Goshi Raghavan Swami has requested through a petition letter that government lands of survey number so and so be allotted to Srimat. According, Panchas came together and appeared on spot. According to 35 acre, 1 acre, 2 guntas, the Bichel village is government land, and survey number 37 of it is found from the land records, government Karajakatta and so and so, and found there are 2 toilet buildings. I'm sorry, my lord has that 148. And found that there are 2 toilet buildings, a cow shed, tea shop, kitchen, rest hut, 2 food centers on the land in survey number 35 area 1 acre 2 guntas, and the said landowners have shown them in time, and that they are in the said survey number 37 1 acre 2 guntas, and the said land is held by Hasanta, Muddalappa, Munnemma, Pushpavati. During the hearing, the panel stated it is cultivating land on temporary basis, and that the monolith Vrindavan of the Raghavendra Swami and the statue of Sri Anjaneya Swami installed by Nanappa and Vyasaraya are in Tungabhadra river, and the survey stated in the presence of the panel, a temporary building shown were built about 8 to 10 years before the Tungabhadra flood of 2009. Buildings of said building were constructed by Ramacharya Bichalli, that is my ancestor, and his brothers. The panel stated that Japadakatti Appannacharya Trust has been formed about the management of the said lands. They requested to make concession, and the Nanjan multi-hold or on lease basis. Therefore, Panchas stated it would be appropriate to settle the matter in the presence of Honorable DC, to whom the said land should be granted concession, and to settle the matter. Accordingly, Panchas have gone to spot, inquired, and Panchas duly recorded. Then, Lord, this happens on the 11th of. This is, my lord, on 8th of June. Then 8th of June, on the same day, my lord, the Tahsildar sends a report. A report is sent by Revenue Inspector to the Tahsildar at page 154. Again, referring to all of these details of the construction that is already there at the spot. Then, my lord, on 17/6, in another 7 days, at page 159, Tahsildar sends a letter reporting all. And in each of these letters, the existence of these buildings by us is specified. Then, my lord, the DC at page 165 writes a letter to AC with respect to, my lord, that suit pending between us. The property. Then, my lord, the AC writes to the deputy commissioner at page 169 saying, no, it is not with respect to the property, it is with respect to puja rights. That's at 169.
When did you file OS 59?
Beg your pardon, my lord, that is in 2022, after all of this.
Which is the date of filing?
Date of filing. Ten 3/22, my lord. 10th of March 2022.
What is the page number of that suit?
My lord, suit starts, my lord, at page number 236, annexure J, 236.
236. This was filed on
10th of March 2022.
and you withdrew it on
Date of withdrawal I don't have, but I'll give it to you. I'll just find out and give it to you. That was withdrawn after the filing of the writ petition.
March 2026, recently. In this
withdrawn in
2026.
26.
I have produced the original certificate.
So this suit,
Yes.
that is why you had prayer number 2. We are wondering why prayer number 2 was there.
Yes.
Now it makes sense.
Yes.
Prayer 2 was, prayer B was because of the grant in 10/3. Sorry, grant order was in February
February.
24 to 22.
Yes.
Within 50 for adverse possession. Yes.
Main prayer, of course, adverse possession. No? That is the main prayer. The other prayers only consequential. If I don't succeed on the main prayer, then the other prayers are of no consequence.
Yes.
Then, my lord, please see at page 169, the AC writes to the DC. Confirming, my lord, that that original, the earlier suit also puja rights determination.
Yes.
Then the DC, my lord, finally writes at 174 to the principal secretary. Specify this and recommending for approval of the government to allot this to the 176. Your lordship will see the proposal. Then, of course, some more correspondence is there with respect to the exact area. But ultimately, my lord, the government then makes the grant order, which your lordship found at annexure K. Which is very clearly at page 255 in terms of rule 108N. Now, my lord, in my respectful submission, merely because it is a matha, there cannot be an automatic grant contrary to law. My respectful submission to your lordships is,
Yes.
if a particular provision has been applied, then the government lord must be able to justify to your lordships as to how that provision has any application. If 108 is the provision under which they seek to exercise power, then there is no case made out that they are an unauthorized occupation of land in any form or fashion. Learned single judge says, oh, your application has not been considered, therefore you cannot therefore challenge it. In my humble submission will apply to them as well. The finding of the learned single judge is, oh, you did not ask for agricultural activities, therefore 108 will not apply to you because it can only be granted for agricultural activities. If it applies to me, my respectful submission has to apply to the Raghavendra Swami Mata as well. There can't be a scenario where the learned single judge will say that I will not examine the correctness of that grant at all, and therefore allow an illegality to perpetuate. When the state government has not exercised the power of Rule 21, if at all it could be exercised, I'll be able to demonstrate that that power could have been exercised under Rule 108. And my lord, in any event, could never have been exercised under Rule 21 of the land grant rules as well. If there is absence of power to grant, in my humble submission to say I will not examine it in my respectful submission is incorrect. And if the learned signature had gone to Rule 108, then the only consequence would have been that the grant that has been made in their favor would have been illegal. And please see their conduct note. The order is passed on 2nd. Within 10 days, a huge posse of police officers come to the property and try to evict us. We resist. Then they do a survey. And then they say, okay, we will not touch the buildings. Last night, a rather large number of people come and say, we will put up boards here. All of that knowing fully well that the matter is coming up before your lordships for consideration today.
Yes.
Therefore, my lord, my respectful submission is that he exists and has been placed before the honorable court. The court, my lord, in my humble submission, must consider it. If it considers it, it is impossible for them, for the government to justify as to how 108 has any application. If 108 has no application, in my humble submission, the grant must go. And they can't take possession on the basis of such an illegal grant. And merely because it is a matha, my lord, in my humble submission, it can't be that they are above the law, or can't be that they are beyond it as well. Or that therefore grants can be made in their favor without consideration of what the law is. And that is what the government has done. It is by being an occupant of that property, in admitted occupation of the property, to be told, you don't have locus standi to challenge it. In my respectful submission is wrong. And that is an admitted position by the government, by the Mata in their objection statement, and everyone else.
Yes, madam.
Those are my submissions, not for admission.
But you're completed.
Yes, ma'am. On admission.
Your submissions are complete.
Yes, ma'am. Whether this is-
One is quash the government order bearing number so and so, which is annexure K, and direct respondent number 1 to 4 to consider immediately the application of the petitioners dated 24/6/2006, copy of which is annexure D. Annexure K, what has been read out. Subsequent to that, there's an order passed by Deputy Commissioner. That's not challenge, your lordships. It is at annexure R13. This is the recommendation of the state government to the Deputy Commissioner. The final order is passed by the Deputy Commissioner, and that is not challenged in the month of March 2022.
Have you produced that? Lord?
Yes, your lordship. It's at R13, your lordships. Of my statement of objections, I've already filed. That's remain unchallenged, your lordships.
The final order is not challenged.
It's not challenged. The final order itself is not challenged.
(24)2 was the proposal.
It's a March 2022, your lordships. That's remain unchallenged.
Yes.
I'm not able to.
550.
Because just so I got the file, I couldn't make it up. So because I had argued it and before the learners, you got to remember, that is not challenged.
Volume 3,
Secondly, your
550.
lordships,
Volume 3, 550 has not been challenged.
I'm sorry, your lordships. Secondly, your lordships, what is annexure D? Annexure D, I would
D.
read it out. in Kannada and then the translation.
Shetty page.
It's only at page number 134, Your Lordships.
134.
It's a typed copy.
No, 136
Six is the English translation. So here, that's a difference.
Yes.
That's what I want to make it out. Here only it is only in respect of survey number 37 they're claiming. And it's only a letter addressed to the Assistant Commissioner, Your Lordships. Here it's nothing with regard to grant of land or saying that they're unauthorized occupant, as unauthorized occupant. May I read, Your Lordships, page number 134, it starts off. ಶ್ರೀಗಳಾದ ಅಪ್ಪಣ್ಣಾಚಾರ್ಯ ಮಠದ ಸೇವಾ ಹೋಮ ಪೂಜಾ ಮುಂತಾದ ಕಾರ್ಯಕ್ರಮಗಳು ಪೂರೈಸುತ್ತಾ ಬಂದರು ಅಲ್ಲದೆ ಈ ಮಠಕ್ಕೆ ಹೊಂದಿರುವ ಸರ್ಕಾರಿ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 37 1 ಎಕರೆ 31 ಗುಂಟೆ ಖರೀಜ್ ಖಾತಾ ಇದ್ದು ಅದನ್ನು ದೇವಸ್ಥಾನಕ್ಕಾಗಿ ಉಪಯೋಗಿಸದ್ದು ಸಲುವಾಗಿ ಕನಿಷ್ಠ 600 ವರ್ಷಗಳಿಂದ ನಮ್ಮ ಹಿರಿಯರು ಸ್ವಚ್ಛತೆ ಮಾಡಿಸಿ ಗೋಶಾಲಾ ಸದರಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಬಂದಂತ ಭಕ್ತರಿಗೆ ದಾಸೋಕ್ಕಾಗಿ ಮತ್ತು ಅಡಿಗೆ ಶಾಲೆಗೆ ಅರ್ಚಕರಾಗಿ ಸೇವೆ ನಾವೇ ಉಪಯೋಗಿಸುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ ಅಲ್ಲದೆ ಸರ್ವೆ ನಂಬರ್ 37 ಈಗಾಗಲೇ ನಾವೇ ಸ್ವಚ್ಛತೆ ಮಾಡಿಸಲಾದ ಭಾವಚಿತ್ರಗಳನ್ನು ಹಾಗೂ ನಡೆಸುವ ಕಾರ್ಯಕ್ರಮಗಳು ಬಂಧನ ಭಕ್ತಾದಿಗಳಿಗೆ ದಾಸೋಹದ ಊಟ ಮಾಡಿಸುತ್ತಿರುವ ಭಾವಚಿತ್ರವನ್ನು ಅಲ್ಲದೆ ನಾವೇ ಸದರಿ ಜಮೀನು ಉಪಯೋಗಿಸಿ ಬರುತ್ತಾ ಭಾವಚಿತ್ರಗಳನ್ನು ಈ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸುತ್ತೇವೆ. ಅಲ್ಲದೆ ನಾವೇ ಸಾಂಸ್ಕೃತಿಕ ವಿದ್ಯಾಶ್ರೀ ಪೀಠವನ್ನು ಸಹ ನಡೆಸುವ ಉದ್ದೇಶವೂ ಕೂಡ ಇದೆ. ಆದ್ದರಿಂದ ತಾವು ದಯವಿಟ್ಟು ಸರ್ಕಾರಿಯ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 37 ನಿಯಮದಂತೆ ಜಪದ ಕಟ್ಟಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲು ನೀಡಬೇಕಾಗಿ ನನ್ನ ಪ್ರಾರ್ಥನೆ. ಟು ಯುಟಿಲೈಸ್ ಇಟ್ for running that is only the application. It's not for saying that they are unauthorized occupant. Secondly, Lord, they are saying for 600 years.
No application.
No. That form number 50 is there. No such application. Only this letter, Your Lordship. And here they say it is since 600 years. Here I would like to bring to Your Lordship's notice, Raghavendra Swami entered Vrindavana in 1671. Recently we celebrated 355. How can it be 600 years? Your Lordship? Simple. Secondly, they have not given it in the form number 50 as under 108C. Then the Raghavendra Swami Devasthana gave an application in the year
21.
No. Earlier there was an application, Your Lordships, I have filed. No, earlier to that. In my statement of objections, I have filed, Your Lordships. Not 21.
Annexure?
Your Lordships, sir. 296 is the translation. It's in 2012. 18/5/2012.
In the translated?
Yes, Your Lordships. Page number 296. Not all of a sudden everything has gone. These people only gave it subsequently. Only after that, all the Panchanama and survey was done.
Volume 1, 2, 3. Where is your translated? Volume 1, 2, 3. No, the translated one volume. Translated. You gave a separate volume for translation. No, separate.
No,
volume.
page. It's 296 as the translation. If my learned friend is referring to 18/5/2012. Volume 2.
296 is the translation.
96. Volume 2.
Volume 2. It's addressed to the Deputy Commissioner, Lordships. It's true that Sri Ramaswamy Vrindavana was established about 345 years ago by its devotee Sri Appannacharya on the banks of river Tungabhadra in Bichali village near Gillesugur camp in Raichuru district. that place land in Karnataka government land, survey number 37, 1 acre, 31 guntas, survey number 35, 1 acre, 30 guntas, survey number 36, therefore, Sri Mata is ready to facilitate the thousands of devotees who come there. It is requested that you, being kind, give that place to Sri Mata, whether for sale, inheritance, or on lease basis, and be blessed with the grace of Sri Guru Ragash. That's only the application. So they wanted either to sale or on lease or any other conditions.
But
They
there is
want
also
to
not
grant
in the requisite form.
in the
There is also a letter. Like how they submitted a letter.
they have given all their income tax returns also.
So
This is the letter.
in the prescribed form, it was given only in 21.
Yes, prescribed from, but it doesn't mean that nothing was there on record. They say 2006 they have filed. 2012, even these people have given in a letter, not in the format. Subsequently, these petitions numbers, there was a dispute. They filed a suit in the year 2016 with regard to
OS 113.
113. In there, everything came out. The petition says that the defendants are using Gunda elements. The defendant says the petitioners are using Gunda elements. And there, the defendant specifically says they were all working in ICRISAT and Hyderabad. One was a professor.
Where is that?
Yes, Your Lordship. In
plaintiff
the written
113?
statement of in 113.
In my statement of objection, Miller plaintiff is at annexure R1
Six.
page 20.
370. Okay.
Page 449, Your Lordship will find that suit. OS 113 of 2016.
449.
Volume 3.
113.
I have produced both the
Another
plaintiff and written statement.
Raghavendra Padada Ramacharya.
They only say that there is no hereditary puja rights
Page.
in the written statement.
Where is the written statement? It's 454.
The written statement is 307, Your Lordships, in my statement of objections. It starts with the 308 para number 6, Your Lordships.
What happened to the suit?
Here, they compromised subsequently. Here, they were fighting for puja rights.
Where is the compromise petition?
That we are not aware. That was the argument made that they compromised. We are not aware of whether there's a compromise.
Compromise petition has been filed, Mr. Chinnappa?
They are not.
No, that's not produced. That's not produced. As a matter of fact, all four of them are before the court, before your Lordships.
Together.
Together. All four of them have filed the petition before your Lordships together.
The terms of the compromise is not there.
No, it's not there. There's no dispute anymore. There's no dispute anymore.
Defense and submits. That
You got
plaintiff
a
number
common
one.
enemy now.
Plaintiff
Government
number one was a
Government seems
research
to be a common enemy.
in ICRISAT Hyderabad. And plaintiff number 2 was working as a regional sales officer for Raptox Pet Pharmaceuticals Hyderabad.
Where are you reading?
Para number 6, page number 308, Your Lordships.
In the written statement.
In the written statement.
Yes.
The defendant submit that plaintiff number 1 was a research officer in ICRISAT Hyderabad, and plaintiff number 2 was working as a regional sales officer for Aptas Blood Pharmaceuticals, Hyderabad. And both having retired from the jobs, do not have any productive work. As such, taking advantage of defendant number one's accident, as is paraplegia confirmed to a wheelchair during first week of September 2012, came to Bitchalli village and started sitting near the Japadakatte by donning the attire of a pious Brahmin, by wearing silk madivastra and putting Gopi Chandana mudras, started thugging unwary devotees by collecting donations in the name of temple and gods at Japadakatte. There were admission. Then the defendants submit that it was washed out. Defendants submit that the entire Japadakatte was washed away in the river Tungabhadra floods of 2009. The defendants were seeking the help of local villagers and devotees to reconstruct the entire setup by seeking for small donations from the duties. But in the meanwhile, taking advantage of the flash floods, the plaintiffs approached the Tahsildar Raichur and filed an application on a computerized, doctored fake letter pad, wherein the plaintiff to illegally claimed to be secretary, and the plaintiff number one claiming it should be as the president of a fictitious organization, Sri Tirtha Kshetra Japadakatte Bitchalli, got sanctioned the compensation amount of rupees 6 lakhs, out of which they got released 3 lakhs and siphoned off the government money. However, with the intervention of the defendants, the government stopped the further dispersal of rupees 3 lakhs flood compensation amount, and the defendants have produced the documents pertaining to the same for the perusal of the honorable court. In this, the prayer is to permanently restrict the defendants from performing the pujas, your lordships. This is the case. And prior to this, what was their father doing? That is evident in OS 59, your lordships. The suit for adverse possession, wherein they say their father was a professor in Usmania University. So none of them stayed at Bitchalli. Neither they nor their father.
Yes.
May I read that relevant portion, your lordships?
What has the state been doing? People will go, they are saying thuggery, and you are sitting allowing people to do thuggery. And innocent citizens will get affected
I
by
think
this.
nobody must have, at that point of time, nobody must have informed.
Must be aware, your district administration must be aware.
They should have looked into, your lordships.
Yes.
Your lordships, page number 237, your lordships.
Page?
237. It is the plaint filed in OS number 59 of 2022.
Hmm.
Pattern number 6, your lordships.
Hmm.
The plaintiff humbly submit that by the year 1950, their grandfather, Brother Gundacharya, by heredity came into possession and started leveling the entire and utilizing the entire government land of developments of major. So and so, survey number 35, 1 acre 2 gutta, and also added the adjacent government land, survey number 37. In 2006, they say only 37. Now they have added even 35, wherein they are regularly conducting Narasimha Jayanti, Hanumana Jayanti, Purandara, Dasa, Aradhari, other rituals and festivals around the year with the participation of devotees from Bitchalli village and surrounding villages. Apart from that, as he is hereditary priest, he used to also organize Munjivi and marriages on regular basis, and the development of Sri Kshetra initially started in the year 50-51. But the government at no point of time objected so and so to the position of the suit property. Survey number 35 initially by plaintiff. The grandfather conversion of the suit properties into Sri Kshetra philosophy reaches destination. The next paragraph. The plaintiff summary submit that after the demise of the plaintiff's grandfather, Bharata Gundachari actual, open, unfettered, uninterrupted, exclusively adverse, continuous possession, enjoyment of fruit land, survey number 31-37, was passed on to the father of Bharata Narasimhachari in the 1980. He was working as a professor in Osmania University, Hyderabad. So these people were staying in Vichalli, and neither their father was also staying in Vichalli. They themselves admit, your lordships. Hyderabad, he used to personal contract and started the real development of Sri Kshetra, Vichalli, and by the year 1982, he had put up lots of sheds in the suit property, including one of the cooking so and so he has put up. That is the point. Secondly, your lordships, in the suit, as per the present appeal, your lordships, the age of Bharata Raghavachari is shown as 75 years. This is in 2026. He had given an application in the year 2006. That is about 58 years. That is only after his retirement. So when they retired from service, they started coming and occupying this place. They were never interested in propagating the religion or whatever it is, whatever they say, Advaita philosophy of Raghavendra Swami.
What is your administration doing in all these things? Administration should take action immediately, not like this. You let all these fester become issues, and now they claim the land to be theirs. Take action at the right point of time. All these things will not happen. Yes, Mr. Augustine.
I want to repeat the facts. I would like to only state that the appellant petitioner cannot come under the shelter of section 108 because the land is not granted for agriculture purpose. Neither petitioner nor the respondents granted for agriculture purpose. We want it for development of the shrine, and the appellant petitioners, they want it for puja rights. So whether it is not for agriculture purpose, there is no grant. So 108 will not come in the way. 108.
You are also not asked for agriculture. You also are not in agriculture. You made the application in Rule
I am
21.
not claiming it for agriculture purpose, for religious purpose I am claiming. And this section 21, my lord, land grant rules. It is how the land should be granted for religious purposes made, my lord. So accordingly, my lord, price was fixed and it is granted for religious and charitable purpose.
But the order has been passed under 108N.
My lord, 108 was relaxed, my lord, because it is not for agriculture purpose. That was relaxed and it is purely for religious purpose, my lord. Unauthorized occupation comes when I am cultivating the land, my lord. None of us are cultivating the land. Neither they nor we. Because it is not an agricultural land. It is a Parampo government land filled with all ancient relics and monuments. So, my lord, we wanted, for the sake of development of the pilgrim center, my lord, want to preserve there in the open land, my lord. So, it's not for agriculture purpose. So, land grant rule, section 21 is clear, my lord. So, there are 3-4 categories of land grant, my lord, for agriculture purpose, industrial purpose, and for housing purpose. So this is for 21 is for grant of land for religious and charitable institutions. The checklist was prepared, my lord. I came under the parameter, my lord. I have produced my economical viability, my lord.
Could you speak in the mic? You may not be able to hear.
It's all right. I can hear my learned friend. So I think he's loud enough. So fortunately.
They cannot claim the shelter of 108 because they are not the cultivators. It is not granted for agriculture purpose. It is for religious purpose. Unauthorized occupation question doesn't arise, my lord. They were all temples. Puja, anybody, it's an open place. Anybody could go and perform puja, my lord. It's open, it's on the open land, my lord. So, my lord, I made an application. So, my lord, under 21, my lord, invoking 21, my lord, land was granted. Since their annexure D, insisting for a prayer, my lord. Annexure D is filed in the year 2006. Since 2006 to 2021, they slept over the matter, my lord. And I filed an application. They compromised together and started opposing. That's
Yes, Mr. Chinnappa, anything?
No, I have only one submission, Lord. I don't see any justification being offered to your lordship as to how power under 108 is exercised, either by the government or by my learned friend. As a matter of fact, his own statement says it can only be if it's agricultural purpose. Now, the mere fact, my lord, that I may not be eligible. Let us assume, my lord, I'm not eligible, but I'm in occupation of the land. That is not disputed. If I'm in occupation of the land, my lord, in my humble submission, it is impermissible for someone else to be granted on the same provision which prohibits me from getting the grant. And therefore, to say 108.
That argument, one small fallacy in that argument. If you are ineligible, you cannot file a writ petition of this kind. You'll have to file a public interest litigation.
No, my lord.
You'll have no locus.
Please appreciate, Lord, I'm in occupation of the land. It is not a situation where it's one rival grant versus the other alone. I'm also in occupation of the land, and that is not disputed. I've been in occupation of the land, Lord, from 1950, because your lordship will find in the RTCs of 1950 the existence of this of structures which were built by my forefathers. It is there. Therefore, as an occupant of the land, I am entitled to challenge anyone, my lord, whose grant has been made under a provision which is not applicable. I'll leave aside, my lord, the grant in my favor. I'll leave aside everything else. The fact that I'm in occupation, in settled possession of this property is not disputed. If that is not disputed, my right, my lord, in the property exists for me to be able to challenge a grant being made in an illegal fashion. And therefore, it is not a public interest litigation in my humble submission which I must file, because I have a sustained and a subsisting interest in the land as a settled person who's in possession for the last minimum 70 years before an application in 2021 was made. Therefore, locus can, in my humble submission, never be made an argument in this case. Secondly, my lord, if 108 does not apply,
600 years has come down to 60.
We do not know. Letters are written at that time. 600 years, no one can prove. Even if they say there's a temple, Anjaneya temple at that time, I mean, I can't really argue on that. Why 600 years? Why not 400 years? Now, even if it is 400 years, they can't prove 400 years. Even if it is 100 years, they can't prove 100 years. We can only prove not from 50 years. From 1950 onwards, there are documents which very clearly show that these structures existed and devotees used to come here. That much is clear. Worst case, not from 2006, not my application is there. As a matter of fact, government will not give us money as flood relief when these buildings were demolished because of flood. We got flood relief. I produced a document.
3 lakhs was released and 3 lakhs was withheld on account of forged for concocted document as per petition number 3 and 4 submission.
The written statement, as per the written statement. I understand. Now, that is not the reason to grant land to anyone else. The fact that someone else is, and that is not the reason also in the government order. It is not as if, my lord, in the government order they've come and said, oh, these are all bad persons, we must not give it to them, we must give it to someone else. This is not, if I may say so, virgin territory where nothing was there, and two rival claimants came and made an application, and the government was required to consider which of the two applicants are better. This is a case, my lord, where one person has occupation of the property, someone else is coming and saying, I want this property for the purposes of development, and you are ignoring my claim and giving the property to a third party under which provision? Under a provision which deals with unauthorized occupation of land, and not Rule 21. Because Rule 21, my lord, in my humble submission, could never have been applied to a religious and a charitable institution. You have to be both. They are only a religious institution, not a religious and charitable institution. And
even if don't re-argue. Don't re-argue.
No.
Reply.
Yes, my reply is only this. There is no answer given by the state or by the other side with respect to how a grant could have been made under 108. Except not throwing mud on us, there is nothing more that has been said. Therefore, in my humble submission, the writ petition ought to have been allowed.
Third, Shri Jan Chinnapallar, Senior Counsel for the appellant, Ms. Archana Tiwari for the state, and Shri Augustine for respondent number 5, reserved.
Lord, may I only make one request, not to your lordship side, let them maintain status quo as on today.
Lord, Paranis are prepared my
Paranis
Parani
are
in my
changed.
name. In my name.
In
My
10
then
days is
position
the
was
order.
given.
Possession is not
Was
been
there an
given.
interim order in the writ petition?
There was a status quo order all through the writ petition.
Status quo was
Status.
then.
Maintain status. If there was an order of status quo in the writ petition,
Lord, copies may be permitted to supply. Copies may be supplied.
still one minute.
Copies ಕೊಟ್ಟಿಲ್ಲ.
But you argue,
ಇಲ್ಲ, ನಾನು ಇವತ್ತು
you just said that. After argument, you are saying.
I'll ಕೊಡ್ತಾರೆ. Copy ಕೊಡ್ತಾರೆ. Let them maintain
If you had
status
said
quo.
that, we would have just adjourned it in the beginning only.
He also late, he just
This
couldn't.
No,
cell number
they-
10 and 11 have taken the entire time today.
They know the case so well, Lord, we don't need papers.
Maintain status quo till further orders.
I'm good.
Lord, according to present situation, because they will go and change the Parani.
Status quo as on today.
As of today.
As on today at 10:40 AM.
Grateful.
Parni will also have the time, so no problem.
Pani, they've already changed. Immediately as soon as the order came, they changed it. It was not even 1 minute. I'm grateful, very grateful to your lordship.
All of you should not have fought amongst yourself. It might not have led to this.
I know, I agree.
Hearing on IA matters, number 12, Pakistan